tell you that I'm an American national and you can hold me in a county jail under bond. Especially today, when I was arrested on a larceny under $200, somebody changed case prefixes and the warrant got dropped to a misdemeanor. And now you're still going to illegally hold me in a county jail under bond?
All right, Mr. Peltel, I'm not going to argue with you. Your sovereign citizen has been.
Folks, buckle up, because today's sovereign citizen doesn't just flirt with fantasy law. He dives headfirst into it. We're talking copyrighted name arguments, American non-citizen national status, sway juris living being declarations, the full sovereign starter pack. Drew Parler appears from jail for what's supposed to be a bond hearing. Instead, he launches into what sounds like a Google-powered legal seminar. Meanwhile, the judge is trying to focus on reality, extradition, repeated bond violations, and a stack of Wisconsin felony charges. But Drew isn't interested in that. His convinced copyright law somehow shields him from criminal prosecution. And as the hearing unfolds, you can feel it building. Because when reality finally hits, it hits hard.
I don't know. All right, so we have Mr. Peltola here.
Ma'am, I'll give
hear
you my name if you can prove charges exist. If not, I'll step behind the bar underneath copyright law.
All right, hold on. I'll call your case and I'll give you the floor. Just page one, if you would, please. Thank you. All right, people of the state of Michigan versus Drew James Peltola, files 247831 SM and file 247819 SM. Mr. Peltola appears from the Dickinson County Jail. Counsel
appellation known as Drew James Peltola appears before you as an entity.
Hold on a minute. Just let me make the appearances, and I'm going to give you the floor, okay? In regard to the matter, Nancy Schaub is here as both his counsel on the underlying file on 247819 SM, as well as the first bond violation. She's here as CAFA counsel on bond violation number 2 in this file, as well as a new file of 7831 SM. Kristen Cass is here on behalf of the prosecutor's office. Drew Peltola, I'm going to give you an opportunity now to say whatever you want to say. Go ahead.
Ma'am, I was trying to get a ride to court this morning. This bond violation.
Wait, sir. I don't want you to talk about the underlying charges. I wanted you to say whatever you wanted to say. I thought you started to say some sovereign citizen information that you wanted to make a record of.
I am an American non-citizen national that's defined in the United States Code. And I do believe that underneath copyright, once my name is copyrighted through the Daily News, once I put that copyright on your paperwork, that's something called copyright impoundment. That means that under Erie Railroad versus Tompkins, the fictitious entity under due process of law does not apply to my sui juris living being.
All right. Is there anything else you'd like to state for the record concerning this issue then, Mr. Peltola?
No, there's not, Your Honor. I would just like to be released again on a PR bond. You have expedition charges. I'm asking the courts to please release me on a PR bond again, and I'll continue to abide by court rules and stay off of drugs and try to maintain my court dates.
All right. In regard to the matter, then, Mr. Peltola, I have an advice of rights and plea, and for the record, I will acknowledge your comments, that your objections in respect to the court's jurisdiction and whatnot are noted for the record concerning your position regarding your status with the court. All your rights are preserved. In regard to the matter, did you understand the advice of rights and plea information form as it was then, Mr. Peltola?
Yes, I did, Your Honor.
How about the bond violation arraignment hearing form? Did you understand that?
I do not have it in my hands, but I read it, and yes, I fully understand.
All right, it's signed by you, today's date. Did you sign it?
Yes, I did. I also brag. Yes, I did, ma'am.
All right, then, in regard to the matter, I also have a waiver of extradition here. I'm going to just go back over what it means to sign one of those. And let me start by saying, so long as you come back to court voluntarily for all your court appearances, this does not become relevant. But if you didn't come back to court, normally you're entitled to what's called an extradition hearing before you are returned to Michigan. And the purpose of an extradition hearing allows you to challenge the legality of your arrest and return to Michigan to fight the underlying charges. And the bond violation, now with the new bond violation, are we going to set both bond violations together, or do you want to proceed on the first one today?
I would like to set both of them together, I think in the interest of justice, and prosecutor had made an offer on the original file, and I think they will be making a new offer. And I think in light of that, it would be best to adjourn those matters on violation in that file.
So we have a jury trial set for March 8th in that matter. All right, did you wish to be heard on bond then on the newest bond violation as well as the new underlying charge?
Yes, Your Honor. Actually, the newest bond violation predates the previous bond violation. The first bond violation is alleged to have occurred on February 22nd. This current bond violation that is being rained on today is alleged to have occurred on February 19th. And in light of that, I would ask the court to consider setting either a reasonable bond or, again, a PR bond. In discussing this matter with Mr. Peltola, he does have criminal matters pending in Brown County, and there is a court date on Monday in that case. It looks like from the lien printout, he may have had some issues either in the past or currently appearing in court. And I'd like to be able to have Mr. Peltola be able to take care of that matter. It looks like it's a more serious matter than the matters in this court. If he can make those arrangements to get down to Green Bay to take care of that. He's given me the name of his attorney, and I intend to contact that attorney and see what Mr. Peltola needs to be doing with regard to that case. So if the court does not grant a bond that he can post, perhaps we can make arrangements for him to appear from the jail here.
All right, concerning the matter, then I have some concerns regarding Mr. Peltola. He seems to be on a spiral. This started with a disorderly drunk on February 4th in a public place. I saw him on February 5th. I set his bond terms. I saw him back on February 12th, with a .236 on a preliminary breath test. I set bond at that time on the bond violation and the underlying. And the reason I told him then that I was going to give him the break is that normally I see people in between, they get arraigned, I give them the warning, and then they come back on a bond violation. He had not had the warning in between because he violated his bond so quickly that I saw him all at once. So I told Mr. Peltola at that time that I would set the bond at a 1,000 PR, but understand that if he came back again, he would leave me no opportunity or new choice. So here we are, not even a week later, on February 19th, stealing alcohol from the Norway Quick Stop, involving another bond violation as well as a new underlying charge that I'm free to assume is true for purposes of setting bond. So for purposes of setting bond today, then for the following reasons, and in regard to his Wisconsin matters, very serious matters, he's got 2 felonies pending in Brown County from 2023. The first one alleges possession of narcotic drugs, a felony, possession of a controlled substance on or near certain places with a modifier, carrying a concealed knife, possession of drug paraphernalia. That case has been pending through for quite some time.
Internet, look at this closely. The judge is calmly outlining the real issues: multiple bond violations, a theft case, 2 pending Wisconsin felonies, alcohol-related violations, and extradition paperwork. Serious matters. And Drew? He thinks the key issue is whether his copyrighted name removes a court's jurisdiction. This is classic sovereign logic. UCC 1 to 308 references. Copyright claims. Sway iure status. The belief that paperwork and wordplay override criminal law. But here's the truth. None of it cancels state jurisdiction. Not once. Not ever. While the judge explains bond factors and public safety concerns, Drew drifts into theories about mailboxes and domicile. It's like 2 completely different conversations happening in the same room, and you can feel the tension rising. The meltdown isn't coming. It's already loading.
And he has a court date for a status conference scheduled for February 26th at 11 a.m. Then, so the date of this offense was filing date of 2/10 of 2023. He's got a filing date of March 15th of 2023 in Brown County, another felony alleging bail jumping as well as possession of drug paraphernalia. Likewise, that has a court date at the same date and the same time as the other pending felony.
I think that is part of the other pending felony. They charge it as a separate offense, but
It's a separate case. Total separate case, total separate charges, total separate bond, total separate court dates. This is file 23 CF 448. The first one is 23 CF 240. So in respect to the matter, my point being for purposes of setting bond, Mr. Peltola has some substance abuse issues going on. He's got numerous cases pending in Wisconsin as well as out here. In regard to the matter, Mr. Peltola, I'm going to direct you to talk to your lawyer. I'm setting bond. Concerning the new theft case, then the conditions are going to be as follows. Mr. Peltola may not enter into the Norway Quick Stop as a condition of his release. He is not to purchase, possess, or consume alcohol or non-prescribed controlled substances. Mr. Peltola is subject to random PBTs and drug screens. Mr. Peltola may not go in any businesses that sell alcohol for use inside, such as bars and taverns. Recreational and medicinal marijuana use and possession are prohibited until or unless further order of the court. Conditioned on him signing that waiver of extradition, which I do have in the file, I will allow him to go back and forth to Wisconsin for purposes of court hearings and or meeting with his attorney. If
in residency, he lives in Wisconsin.
in residency, no, he lives in Vulcan, or he says Vulcan. Is that just your
Bracketed.
mailing address?
Yes, we can do it like that if you choose to.
Well, where is your residency?
My residency and my domicile.
And that's your mailing address, though?
Yes, but the problem is that building's not registered anywhere. I had to go to the post office and I had something mailed and they told me that my mail was being returned and because there's no actual mailboxes in the building.
All right, so I got two issues I need to deal with here. One, do you live in Wisconsin? Do you have to go to Wisconsin for purposes of residency or just your court stuff?
My mailing address, my residency, and my domicile are all registered at my mother's house. There was some unexplained events that I will not say out loud.
I don't know where your mother's house is, Mr. Peltola.
In
regard to bond, then condition on him signing a waiver of extradition, I'll allow him to go back and forth between Michigan and Wisconsin for residency, court appearances, meetings with his attorney. In regard to the matter, if you relocate for any reason, you must provide the court with an updated address and phone number within 7 days of any change. Concerning the amount of the bond on the new retail fraud, I'm going to set that. I'm finding for both of them, actually, I'm going to make a record based on the factors the court is required to consider under MCR 6.106, considering the frequency, the charges, the dates that I have mentioned, as well as the ongoing Wisconsin matter. I am finding that to release him on a personal recognizance bond would not adequately ensure public safety. In regard to the bond violation, concerning the matter, then I am going to set the bond violation at $2,500 cash surety, 10%. So, Mr. Peltola, those bonds are set. If you get out, you make sure to get in touch with your lawyer. If you're in custody, she'll be in touch with you. You may.
Yes. You know, I don't understand how I can tell you that I'm an American national and you can hold me in a county jail under bond, especially today when I was arrested on a larceny under $200. Somebody changed case prefixes and the warrant got dropped to a misdemeanor. And now you're still going to illegally hold me in a county jail under bond?
All right, Mr. Peltola, I'm not going to argue with you. Your sovereign citizen has been noted for the record. In regard to the matter, you are under the order of the court. You're under the jurisdiction of the court. I decline to follow what your,
Can I at least tell you, admit I was arrested on a larceny charge that was dropped through a case prefix, UN, all incoming evidence? Can I at least have you admit that in the court of law that you guys illegally kidnapped me again with a larceny through John Rod D. Clark, Norway Police Department? Can I just have you admit that once?
No, Mr. Peltola, I don't even know what you're talking about. I will not admit that. Thank you to the jail. We are off the record on this matter.
Let's break down what really happened. Drew was given chance after chance. The judge reviewed everything: disorderly conduct history, repeated alcohol violations, 2 Wisconsin felonies, new theft allegations. Each time, he was warned, another violation leaves a court with no room to maneuver. And when he returned yet again, the judge made a structured, legally grounded bond decision based on risk, public safety, and repeated noncompliance. But instead of addressing any of that, Drew doubled down. He insisted his name is copyrighted, claimed as an American national outside jurisdiction, argued the jail is kidnapping him, and like so many before him, he ran into the same wall. You cannot talk your way out of criminal jurisdiction with fictional legal theories. The judge remained calm, direct, and final. You are under the jurisdiction of this court. End of story. If you enjoy watching sovereign arguments collide with real-world law, hit like, drop your thought below, and subscribe for more courtroom breakdowns. And turn on the bell. You won't want to miss the next collapse.